Anderson Cooper, AC 360, CNN weeknights 10 Eastern.
Mr. Boyce, for you, what are the most important points in the judge's decision?
And here in California, it doesn't matter.
The most important points in the judge's opinion were three.
It doesn't matter.
First, the judge held that marriage was a fundamental right for all individuals. Second, the judge held that depriving gay and lesbian citizens of the right to marry seriously harmed them and seriously harmed their children. Third, the judge held that depriving gay and lesbian citizens of the right to marry had no benefit, no legitimate benefit to society. It didn't help preserve heterosexual marriage. It didn't help heterosexual couples. It didn't have any rational basis. And the judge found those three principles based not only on an extensive amount of evidence that we had put on, but on the things that the defendant's witnesses had actually admitted in court.
Mr. Olson, it does seem during the trial that your opponent's witnesses almost kind of argued in your favor because they seem to help you more than they hurt you.
Well, that it was the case. And in part, they were assisted by David Boyce's skillful cross-examination. But the real fact was that we brought in evidence from experts, the leading experts from throughout the world on marriage, the history of discrimination, the damage that's done by discriminating against gay people, the raising of children and so forth. They did not have comparable evidence, and they did not have comparable experts. The experts that they did have really didn't have much to say, and they really had to admit that discrimination is wrong, that gays and lesbians can raise children, and they'd raise children in a very, very happy family, and that discriminating against them does no good. It is un-American, it is unequal, and it's unfair. They had to admit this. I give great credit to David Boyce for bringing that out in cross-examination, and the judge made the point at the end of the trial in this decision today that their evidence didn't amount to anything, and it was overwhelmed by the evidence and the experts that we put on.
And Mr.
The thing to keep in mind,
go ahead.
The thing to keep in mind is that they were defended by very, very good counsel. The problem with the defendant's case is not that they didn't put on their best case, but that simply their best case didn't have any rational basis for this kind of discrimination.
I mean, it seems like they had no evidence to argue the point that changing marriage, traditional marriage, that allowing same-sex marriages actually will negatively impact opposite-sex marriages.
That's exactly right. And the key issue that they had argued, the defendants had argued before trial, is that somehow allowing gays and lesbians to marry would harm heterosexual marriage. Now, there's a certain lack of common sense in that argument. But the key thing is that at trial, not only did we bring in empirical evidence that showed that that had not happened in any of the places where you already have marriage between gays and lesbians, but the natural understanding of what the purpose of marriage was made it clear that that was not going to happen. And finally, even the defendant's own experts admitted that there was simply no evidence that there would be any harm to anyone, any heterosexual marriage, the institution of marriage, any harm to anyone that would come from ending this discrimination.
Mr. Olson, the strategy that the opponents of same-sex marriage used in the Prop 8 campaign was very different than what they argued in court. During the campaign, they were basically playing upon fears, parents' fears that their children would somehow be indoctrinated in school, but they didn't use that argument in court. Why not?
Well, I think that what they realized is that you are correct, that during the campaign they argued that it was necessary to pass Proposition 8 to protect our children from thinking that it was okay to be gay, that it was okay for gay people to have the normal marital relationship that the rest of our neighbors do. They realized that that sounded and was discriminatory, that it recognized or it called out for people to think upon gays and lesbians as different and unequal and less favored. So they abandoned that during the trial. They knew it would not work. And then they resorted to this idea that somehow allowing your neighbors to get married would somehow discourage heterosexual couples from getting married or having children, and evidence didn't support that. So they tried one thing during the campaign, then they abandoned that, and they tried something else during the trial, and that didn't work either.
And Mr. Boies, to those who say, why not have domestic partnerships, why marriage?
The communities that have
Well,
come to realize
what the judge found and what all the evidence showed was that domestic partnerships were not equal to marriage. That when the state sponsors discrimination against gay and lesbian couples by saying you have to have this second-class status, you can't have marriage like normal people. That is the worst kind of state-sponsored discrimination. We have a lot of areas in this country where we still have a long ways to go before we achieve the kind of equality that our country was founded believing in. But this is the only area in which the state actually has official state-sponsored, state-enforced discrimination. And when the state says to gay and lesbian couples, you're not good enough for marriage, you have to be settled for domestic partnerships, that is straight-out discrimination. And the judge found it had harmed gays, it harmed lesbian couples, it harmed their children, and it had no benefit to anybody.